Welcome to the United Progressive Party Command Center. As you know, this is where we operate from, and this is where our operations are aimed at winning the next general elections with the people of Antigua and Barbuda. We are confident that we will win. I want to extend our appreciation for you turning up this afternoon to this press conference. We believe that it is important for us to talk to you, since you talk to the people en masse along with us when we do so. The reason for the press conference is to comment a bit on the Privy Council's decision today in the case involving the Commissioner of Police and the Attorney General versus Stedroy Cutie Benjamin. We will again show you how the Antigua Labour Party leadership continues to swim along the borders of criminal activities. Sister Joan Messiah will give a brief on the Privy Council's decision, and after that I will talk a bit about why, when we say ALP, criminal matters, UPP, leadership matters. Sister Joan.
Thank you very much, Brother Chaku. As was said, I just will give a synopsis of the decision, but I think it's important for us to appreciate the timelines which are involved in this matter. At the outset, I wish to state that it has taken 6 years for this matter to be resolved. And this is a matter which started in July of 2008. As you may be aware, this decision by the Privy Council essentially answers the question as to whether the Director of Public Prosecutions, the DPP, has a general power to prevent the police from instituting criminal proceedings in a matter. And the Privy Council answered that question with a resounding no. This is a matter which involved the issuance of an Antiguan and Barbudan passport to a Jamaican national, one Shane Allen, in the name of Tyrrell Dusty Brand, who was an Antiguan and Barbudan citizen and who at the time of the issuance of this passport to this Jamaican national was dead. By way of background, an application had been made to the passport office for the issuance of this passport. Stedroy Cutie Benjamin was the attorney who signed the passport application and who certified 2 critical things. One, that the passport picture which he certified was in fact that of Tyrrell Brand, when in fact it was not, and that the person before him was Tyrrell Brand, whom he certified he had known for 2 years. Thereafter, the application was taken to the passport office and a passport duly issued. Shane Allen, who was the true individual, who was purporting to be Tyrrell Brand, traveled overseas to the United Kingdom, and there the authorities, on some suspicion, investigated the matter and in fact found that Shane Allen was not Tyrrell Brand, and he was sent back to Antigua and Barbuda. On his return, the police began an investigation. And this investigation was being conducted by one Corporal Ogaro, who on July 24th began an investigation into the circumstances surrounding the issuance of a false passport. And this was issued in June 2008. On July 25th, Corporal Ogaro inspected the application form and he observed that it was signed by Cutie Benjamin. On July 26, Corporal Ogaro interviewed Cutie Benjamin, and subsequent to that interview, requested that Cutie Benjamin provide a witness statement to the police. The court notes that Cutie Benjamin stated that at no time during his interview with the police did Corporal Ogaro ever caution him. This is what some persons might know as the Miranda warning in the United States, where they say you have a right to remain silent, anything you say or do can be held against you. We all know that from watching criminal shows. In fact, Cutie Benjamin stated that he understood that his only role in any court proceedings thereafter would be in the form of him serving as a witness for the prosecution in the event that the prosecution opted to bring a charge against those persons who he said had secured the issuance of the said passport. On July 29th, the DPP requested that Corporal Ogaro bring the file, the police file, in respect of Cutie Benjamin. And thereafter, it is said that the DPP advised Corporal Ogaro to, quote unquote, hold on for a while and not to lay any charges against Cutie Benjamin until further notice. It goes on to say that the DPP had advised that in his view, guilty knowledge could not be established against Cutie Benjamin, as this situation could have happened to anyone. On August 4th, the office of the DPP confirmed these instructions in writing in respect of not laying any charges against Mr. Benjamin. In spite of this, on August 7th, Corporal Ogaro decided to lay a complaint against Cutie Benjamin pursuant to Section 6 of the Forgery Act, which is a summary offense. On August 9th, Cutie Benjamin was served and they were to return to court on August 11th, but the matter was adjourned until September 23rd. On September 22nd, 2 further charges were laid against Cutie Benjamin in respect of the said Section 6 of the Forgery Act, in respect of the certification of the photograph, and in respect of the certification that Cutie Benjamin knew Mr. Brand for 2 years. Both were false certifications. On September 23rd, the day when the matter was to be heard, the matter was adjourned until November 19th. On November 7th, Cutie Benjamin filed an application to the High Court for leave to apply for judicial review of the Commissioner of Police's decision to lay complaints against him. He asserted that the DPP, having given instructions not to lay charges against him, that the Commissioner of Police's actions were unlawful. And he sought an order that the summonses be quashed, and he alleged that the Commissioner's decision was based on improper political interference by the Minister of Justice and the Attorney General. On July 31st, 2009, approximately 1 year later, his application was heard before Justice Harris, and Justice Harris refused to grant the application. The court ruled, the High Court that is, that the DPP did not have the power to prevent the police from laying charges, and that any other allegations in respect to political interference could be dealt with by an application to the Magistrates' Court. Cutie Benjamin thereafter appealed that decision to the Court of Appeal, which on September 19, 2011, overruled the High Court's decision. Thereafter, both the Commissioner of Police and the Attorney General appealed the order made by the Court of Appeal to the Privy Council. And this is where we are at this time. Having examined the various points raised on appeal by both the respondent, Cutie Benjamin, which involved a number of constitutional issues which they raised, the Privy Council ruled that, contrary to the decision of the Court of Appeal, that in fact the appeal made by the Attorney General and the Commissioner of Police should be allowed, and that the orders of the Court of Appeal should be set aside, and that the decision of Justice Harris in the first instance should have effect. The court further ordered that Cutie Benjamin should pay the cost of the appellants and any other costs incidental to the appeals of the Court of Appeal and to the Privy Council. Now, what in effect does that mean? In effect, in the United Progressive Party, we believe that the decision of the Privy Council is a victory for the people of Antigua and Barbuda, and in fact, that the decision of the Privy Council allows us to reaffirm our confidence in the Privy Council in dealing with matters generally, but dicey matters such as this involving interpretations of our Constitution. As I said earlier, it has taken 6 years to come to such a resolution, but given the decision which has been rendered, we believe that it is 6 years well worth the wait, as simple as this matter had appeared to the majority of the people of Antigua and Barbuda. Consequently, in light of this decision, the United Progressive Party is of the view that Cutie Benjamin must voluntarily step down as a candidate for the 2014 general elections. We believe it is the honorable thing to do, and that persons seeking the highest executive office in Antigua and Barbuda must be honorable in their actions. They must not have criminal charges pending against them, and that if Cutie Benjamin refuses to step down, we call on the leadership of the Antigua Labour Party to insist that he be removed and to so remove him as a candidate for the general elections of 2014. Thank you very much.
Now, it must be noted that at the time Mr. Benjamin was charged, he was the leader of opposition in Parliament. But what is interesting about this 6-year-old case is that it is very characteristic of the Antigua Labour Party and its leadership to use the court system and their resources to delay their meeting with justice. You may recall that Asset Michael filed more than 40 injunctions during the IHI criminal matter, seeking to avoid investigators getting to his bank account, which it is alleged public funds were in. You may recall that Lester Bird sought to stop the IHI Commission of Inquiry through the courts. You will recall that the Antigua Labour Party challenged the results in 4 constituencies, despite it was clear that the party had won those seats handsomely. You will recall that the Antigua Labour Party challenged the boundaries report. You will recall the Antigua Labour Party challenged the re-registration of voters. So there is a pattern, a strategy employed by the Antigua Labour Party to the best of their ability to manipulate the court and to use resources to obstruct justice insofar as it is sought against them. You also recall, because what this case really does, it further indicates what the leadership of the Antigua Labour Party, past and present, is about. As part of the press, I'm satisfied that you have seen the collection of tapes known as the Untouchables. Tapes that have been played publicly, that have heard a voice which clearly, seemingly is Asad Michael, expressing fear that his mother would be charged with money laundering. We have heard tapes of conspiracy by the leadership of the Antigua Labour Party to remove one of their own, Robin Yearwood, as leader of the opposition. We have heard conversations regarding payments to Asad Michael on behalf of Robin by one Roberts for APOA building. We have heard tapes concerning a conspiracy to kill the father of the nation, V.C. Byrd, because he was staying too long to die when they wanted to take power. We have heard none other than Leicester's deputy for many years, Hugh Marshall, at a public meeting alleging that in the building of the Royal Antiguan that bribes were paid on the instructions of Leicester Byrd. What we have seen is a pattern of criminal conduct by the top leadership of the Antigua Labour Party. So much so that when we think now of criminal matters, we think of the Antigua Labour Party. Compare with when we talk of leadership matters, we speak of the United Progressive Party. Now, members of the Antigua Labour Party have been flirting with the law, flouting the law, and in some cases have been convicted and are candidates today. That is shocking in any contemporary democratic society. Chet Green, from our research, was convicted for forgery some years ago. Dean Jonas recently was convicted for battery. Cutie Benjamin is now no longer. The case is over now. The court says go to trial. So we have a fraud case pending against him. And tell you what, there are at least 2 more cases that they have discovered involving similar conduct with the same individual. No prosecution went forward on those 2 because this case was pending. The courageousness of the police in going forward with these matters and that they were pursued to the Privy Council, I think they must be commended, and the community is looking to see the same courageousness going forward with other criminal matters involving the Antigua Labour Party leadership. You may recall, the Antigua Labour Party likes to tell us that our memory is short, but you may recall that Asad Michael currently is awaiting trial for battery on a police officer. When the police officers had conducted the raid over at Dry Hill, that case is still pending because Assad challenged the warrant, and that case involving the warrant, which is associated with this case, is pending in the Court of Appeal. Now, what should happen? Sister Joanne has already told you what we think will happen. Cutie Benjamin should step down as a candidate with all deliberate speed. It is the honorable thing to do. You do not seek an honorable office while criminal charges are pending. Cutie has the opportunity to clear his name. Let us make it clear. We are firmly committed to the principle of a person is innocent until proven guilty. We are not pronouncing his guilt. The court will do so, one way or the other. If Mr. Benjamin fails or refuses to step down, then the onus now is on Gaston Brown to demonstrate that he is a different leader than his predecessor, Lester Bird, and remove Cutie Benjamin from the ticket. You will recall, in fact, if Gaston fails to do so, he will be demonstrating that he is no different than Lester Bird. You will recall that after the Bloom-Cooper inquiry, they make a recommendation that V. Bird Jr. never hold public office again. They left him out of government for a few months, and then Lester Bird brought him in. You may also recall that when Malvin Joseph was involved with the Rolls-Royce matter, that Lester Bird removed him for a short while, then brought him back in. Gaston Brown, you have the opportunity to show the people of Antigua and Barbuda that you are different, that you will not go into an election with persons who have criminal matters pending over their heads. I want to make that clear. We believe in the well-settled principle of innocent until proven guilty. But this is not about guilt. This is about principle. The principle that one does not seek honorable office while under the cloud of prosecution. At elections, the people elect lawmakers. Lawmakers cannot be lawbreakers at the same time. Thank you for listening to us.